Good afternoon, all. Welcome. My name is Chiara Liguori. I work at Oxfam, and I'm pleased to welcome you here today. So in this press conference, we want to slightly zoom out a bit out of these negotiations, just to connect really with the demands of frontline communities, just for us to be grounded in those. And those communities that are already suffering the most because of the inaction and the wrecking pollution of rich countries. And so the demands that they have are demands of reparations, of justice, and so not just monetary compensation, but full reparations that take into account the needs and rights of all affected people in all their diversity. And so outside of the UNFCCC, the conversation on climate reparation is progressing. So today, in this press conference, we want to hear from our panelists, particularly how the conversation is evolving under international law, and under human rights courts, national courts around the world, and more broadly, what these demands for climate reparations are. So I'll now give the floor to Elisa Morgera, who is the UN Special Rapporteur on Climate Change and Human Rights.
Thank you so much for this opportunity for all of us to reflect on the really crucial issue of remedies for climate harm and reparations. From my side, as UN Special Rapporteur on Climate Change and Human Rights, I am contributing to that clarification of international law applicable to this question, and in particular what international human rights law says in the light of the science, and in fact multiple bodies of science that clarify the harm that climate change, climate inaction, ineffective climate action is doing on human rights. In my most recent report, which has been published last week online, and I will be discussing in Geneva at the Human Rights Council on 30th of June, I have reflected in particular on the human rights obligations of states to phase out fossil fuels and related subsidies, and in that context also clarifying the content of the human right to effective remedies as part of state obligations in relation to fossil fuels. And something I would like to share with you for our conversation is, in fact, how from multiple sources of international human rights law, we're understanding the importance of effective remedies as a way to protect also the human right to health and a healthy environment, as well as the right to development, facilitating, I think, individual and community healing based on how we can restore human connections with nature and support intergenerational alliances. And I think crucially, because in so many ways climate change is depriving many of us, in particular countries who have been most affected by climate change for over a decade, children, women, young people, persons with disabilities, indigenous peoples, small-scale fishers and small-scale farmers who are most affected by climate change. The effective remedy should also be seen as a way to create the space for transformative change. And it's important to look at all the remedies that international human rights law provides for as ways to effectively implement also primary obligations of states in relation to climate change, including in relation to the phase out of fossil fuels. So thinking about guarantees of non-repetition, and so the report proposes an approach to defossilizing our economies, really going both in the light of climate science, but also biodiversity science, planetary health, human health science, all indicating how every phase of the full life cycle of fossil fuels is harming the planet and harming human health in multiple ways that may become very quickly irreparable. But equally also the importance of satisfaction, of clarifying how fossil fuel companies have, for over 6 decades at least, undermined our public debates, our understanding, our science around the negative impacts of fossil fuels on human rights and the planet in multiple ways. And it is essential then to think about compensation, both in terms of monetary compensation and in terms of restitution, for instance, of indigenous territories, of other territories of African descendants and peasants that have been negatively impacted by fossil fuels over generations, and that maybe should still be prioritized if their return is desired and made possible through the dismantling of fossil fuel infrastructure, ecosystem restoration, and full remediation of any toxic contamination and legacy. But crucially, it's important to think around the sources of funding that can be used in terms of compensation, and understanding the obligations of states in light of their historical responsibility, current contributions, and respective capabilities to provide that financial compensation for damage caused throughout the fossil fuel life cycle, domestically and extraterritorially. And we have important and diverse ways in which that can be done through legislation. We have examples of setting and enforcing strict financial penalties for human rights abuses by fossil fuel companies, requiring those companies to finance upfront climate adaptation, mitigation, and loss and damage. And that has been done in some cases through what are called climate superfunds. I think taxation is a key area that needs to be looked more and more closely, including tax avoidance and evasion, and how that in and of itself is a driver of continued fossil fuel expansion, as well as the question of wealth taxes. And how all in all these forms of remedies are essential for us to create the space for rethinking our economic models, which are essentially what is driving climate change more broadly. And the final point I'll say is how important and essential it is for the identification of those remedies to be a matter of co-development with affected human rights holders in accordance with their assessments of the impacts, their holistic valuations of loss and damage experienced, and taking into account both intersectionality, so the multiple grounds of vulnerability and discrimination that certain human rights holders are facing in being affected by climate change, as well as structural discrimination. And all of that then needs to be responded, of course, through access to justice, and then feeding into a process of co-developing remedies that can be the seeds for alternative economic systems that can support both climate mitigation, adaptation, the prevention of further loss and damage, and crucially, yet another dimensions of international human rights law, ensuring maximum available resources, both financial, but also in terms of the ecosystem services and benefits, all the contributions that the Earth system as such provides to climate regulations, to our human well-being on the planet, for all states to be able to fully realize economic, social, and cultural rights in the context of the planetary crisis we are facing.
Thanks so much, Elisa. So I think we have a clear need to read a report which really highlights what the right to remedy means in the context of the fossil fuel economy. And linked to that, so we have set what the international law says. We also want to see how we can use international law through especially the international courts. And so I would like to give the floor to Vishal Prasad, who is the director of Pacific Island Students Fighting Climate Change.
Thanks, Chiara. Bulavinaka, everyone. It's great to be part of this panel discussion, and also following after the special rapporteur, which very nicely summarized the discussion around climate reparations and the discussion around climate harm that many frontline communities, vulnerable communities are facing all throughout this world. I wanted to just speak to one of the very key campaigns, one of the very key initiatives that's currently ongoing. It's before the International Court of Justice, which is the request for an advisory opinion on the obligations of states in respect to climate change. This was a civil society-led initiative that came out from the Pacific, and it was supported by many countries alongside civil society around the world, and it made it to the UNGA, and it's just concluded a few months ago its oral hearings, where we saw a number of arguments that were made along similar lines, that similar to what the Special Rapporteur has mentioned around how climate change is causing significant harm to people and the planet, and how there should be a right to remedy as a result of this. And if I could just draw attention to the legal question that was asked of the ICJ, which particularly is useful for our discussion today, is the first asking the ICJ on what are the obligations of states under international law to ensure the protection of the climate system and other parts of the environment from anthropogenic emissions of greenhouse gases for states and for present and future generations. So essentially asking the obligations of states to prevent significant harm. And the second question is on what are the legal consequences under these obligations where they, by their acts and omissions, have caused significant harm. And we've heard about some of the consequences that the Special Rapporteur has already mentioned, and that is particularly argued by many small island nations and vulnerable countries that give rise to the duty to make reparations as secondary obligations under international law. And so all of this is very significant and very interesting developments in international law because the power of the advisory opinion, I should say we expect the advisory opinion in a few months, hopefully. The power of the advisory opinion is that it's a very significant authoritative clarification of international law on what the obligations of states are and what duties and responsibilities they have and what the consequences are, so that these discussions that we're having around reparations, they need not be just centered in international courts and international law, but they do have a role to play and they can be brought back into, say, the negotiation spaces and the UNFCCC. And it would be very interesting to understand how the ICJ interprets and clarifies, or we believe advances the discussion on reparations, and how we can all bring that into spaces like this so that it can have a direct link within discussions such as on loss and damage and beyond. And so it's a very significant moment for international law, because we are at a moment, we call it a watershed moment, a historic moment, to kind of reimagine how we look at these discussions, these very important discussions that affect people and communities very, very significantly. And so as we await the advisory opinion of the ICJ, we as civil society, we call on everyone to look out for this decision. It's a very significant one. And as we go into COP30, it would be very interesting for all of us to be armed with the law, with what the ICJ says about many of the obligations of states, particularly also in relation to reparations, and how can we translate that into spaces like COP30 and beyond. Also, with the legal developments that have been happening, also I should note the Inter-American Court of Human Rights is also expected to release its advisory opinion, which heavily deals on the topic of reparations, and I believe it would be coming out in a few weeks. And that would also add to the body of law that's been developing around this. And so picking up on what the Special Rapporteur said, there is a lot of work done in this, and now I guess it becomes incumbent on all of us to see how can we take it into spaces that's not very it's the idea of reparations is not usually discussed in, and how can we mainstream those into those spaces. So yeah, I'd like to maybe stop there.
Thank you, Vishal. Moving, even zooming even a bit more, we could now hear from Lynn Van Dam, from the senior campaigner at the Center for International Environmental Law, which I believe you're going to also dig a bit more into the hearing that were done last year at the ICJ, and understanding how the case for reparations was made there. Thank you.
Thank you, Kia, and also thank you to Elisa and Vishal for setting the stage very well. As Kia said, I will go a bit deeper into the oral hearings and how reparations actually showed up in the International Court of Justice hearings in December. So as was already mentioned, states have legal obligations to prevent, minimize, and remedy foreseeable human rights violations. And so the people on the front lines of the climate crisis, they have a right to remedy for that climate harm under existing law. And accountability, remedy, and reparations are core elements of climate justice. But despite those long-standing obligations and an escalating crisis, we have seen decades of denial, reliance on voluntary approaches, persistent attempts to circumvent and avoid liability for climate harm in this very process. And to date, under the climate regime, no redress for climate harm has reached communities on the front lines of the climate crisis. And that is because wealthy nations with high cumulative and existing responsibility for the climate crisis, they have successfully created a taboo on discussing or providing climate reparations in this process. But as was already introduced by Vishal, the tables are clearly turning. Because what we've seen in the oral proceedings of the ICJ is really unprecedented. Not only has the court never seen such a high-level engagement of states. Importantly, the majority of those states made sure that climate reparations were really a flashpoint in these proceedings. And while major emitters came to the court and they attacked the foundations for remedy and reparations for climate harm, the majority of states took the opportunity to finally break the taboo and assert the right to remedy and reparations for climate harm. I don't have enough time here to go into all the legal arguments that were made, so I will focus on some, starting with one of the main arguments that was made by climate-destructive states, which were centered around the claim that climate treaties, and in particular the Paris Agreement, are the only relevant bodies of law in the context of climate change, and that international cooperation under this process, under the climate regime, substitutes for legal consequences for breaching obligations. That outrageous argument really neglects the reality that the climate regime has consistently failed to deliver any form of support to climate-vulnerable nations and communities on the front lines of the climate crisis to address the harm that they are facing, and it essentially denies the relevance of international legal obligations that long predate the climate regime, and accepting such arguments would really create a legal vacuum in terms of historical responsibility specifically. But so in stark contrast with those arguments, the majority of countries made clear that today's devastating climate impacts are the result of actions that breach international law, and that those responsible for that harm can be held accountable under existing law. And in its opening statement, Vanuatu was very clear. Countries must stop causing harm. Countries must ensure that it doesn't happen again, and they must provide meaningful repair to those affected through restoring the damage, offering compensation, and also acknowledging the wrongdoing. Many states also pushed back against big polluters' claims that climate agreements like the Paris Agreement let them off the hook. And as specific nations have long made clear, signing these agreements here do not erase other long-standing legal duties. Another reason why the court proceedings were really, and its records are so immensely valuable, is that it also gives insight into what climate-vulnerable states consider as appropriate forms of remedy and reparations for material and non-economic harm. The reason why that's so important is because the reparations taboo in the climate regime has really made it impossible to discuss these kind of things, these kind of questions. What would it mean to actually repair the harm that has been caused? And so it's really worth having a look at all of those arguments. Again, I don't have time to go into it, but it's really worth looking at what states have argued would actually, what repair would look like in their specific context. Importantly, states have made clear that it's not just about compensation, monetary compensation, but it's really also about taking systemic measures to repair the harm, for example, debt cancellation and relief in that context. So I'll conclude in saying that that the fact that these arguments have surfaced so clearly in the court proceedings is really important. As was said, the advisory opinion is expected in the coming months, so before COP30. And we're really looking forward to that advisory opinion confirming that climate-destructive conduct triggers legal consequences under international law, and which could lay the foundation for really meaningful, comprehensive reparations and fundamentally can reshape the way that we look at loss and damage, addressing loss and damage in the UNFCCC and beyond. So I'll stop there. Thank you.
Thanks so much, Lynn. And so now, having heard how the international law can be used and international courts can also be useful in this context, I would like to give the floor to Adriana Vázquez, who's operational director at La Ruta del Clima. Really, because of all your experience of researching human rights and loss and damage in local communities, we really would like to hear from you what this demand for climate reparation is in practice.
Thank you. I think it's important that we start by recognizing the historical damage that our communities suffer every day. Communities in Latin America, particularly, every day face the challenge of surviving. Our people, it's affected in a different way from the countries of the global north, and it's important for us to have that in mind when we are thinking about reparations. The countries of the global south are more impacted and have less resources to address loss and damage. We are suffering irreparable losses and damages in lives, territory, physical and emotional health, and our identity and our future is in danger. Climate reparations involve not only the transferring of resources, but also compensating for loss, recognizing the loss, and not repeating the damage. And I think that's the most important part, not repeating the damage. Climate finance architecture right now, it's unjust, it's inaccessible for our countries, it's insufficient, and it's ineffective. And that leads us to repeat the colonial dynamics that we have become indebted with the global north, who is the responsible of the situation that we are living. Our traditions and our culture are being lost. We heard every day stories from the communities, how they have stopped doing activities that for them were very important, and simply because of the change of their community, they are not available to repeat it. It is urgent to move from the logic of assistance to justice. We need a just response for our communities. We demand reparations, we demand justice and the fulfillment of rights, and reparations are moral, historical, and a legal debt from the north to the south. To talk about climate reparations, the voices of the global south must be at the center of the discussions. We cannot be out of this space of discussion. Thank you.
Thanks so much, Adriana. So I think it's now time to hear if there is any questions from you. While you think about it, I wanted to ask if you have all thought a bit more how, if provided that we have that the courts, in their advisory opinion upcoming, recognize as we believe, the right to remedy and formulate this, provide much more clarity around this, how this could then be used in climate negotiations. I know we are still all grappling with this question, but if you have any initial thoughts, I think would be useful in this context. Sorry.
Well, I think that's a really important question, and there may be many ways in that can be done, and there's different roles for all stakeholders in the process to support that process. I think for states to bring up relevant arguments from the advisory opinions in the context of the negotiations, including, I think many speakers said, challenging some of the dominating framing and approaches that are currently characterizing this international process will be essential. There's a question of reprioritizing the kind of responses, changing some of the systems that perpetuate harmful practices that prevent the cessation and non-repetition of activities that are contributing to climate change. But there's also many other aspects that around the international system that would also have to change. A whole question of restructure our international economic systems. That we've mentioned that, but we've also discussed earlier on this week the need to rethink completely international investment law. We know that other areas of international law are very relevant, including in terms of health, nature, the ocean. And so in a way, those advisory opinions should really infuse all future international cooperation across all areas of international law that are either impeding progress in terms of climate mitigation and protection of human rights, or could play a much bigger, more effective, and more inclusive role in advancing meaningful climate responses and reparation for climate harm. And of course, any researcher, civil society, technical advisors, and I would stress UN officers who are all bound by the UN Charter, they're all also called upon to, I think, recall to parties where those advisory opinions serve to clarify human rights obligations that need to inform any work under the aegis of the UN.
Thanks, Elisa. Any other thoughts or any other questions? Oh, Silvia.
Hi, thank you so much for this panel, Sriram Madhusudan. I'm with U.S. Climate Action Network. I'm wondering, we're meeting in a dangerous moment for multilateralism globally. What are the panelists' thoughts on how climate reparations is an avenue to also restore trust in a multilateral process that has really failed to deliver what we've needed for so long?
Okay, so I think it's a tricky question. It's hard to have an answer, and it can lead to reformulate a lot of the things that we have agreed in the last years. And I think the important is to have a strong position as civil society and as communities that are being affected by climate change, and to work together, because at the end, we all want the same, and to trust that it's going to be like a good change, like to bring the discussion inside and outside these spaces. Yeah.
Thank you for the question. Just to add, I think with the developments with these advisory opinions coming out, we also have an immense opportunity to kind of reshape the whole multilateral process to be more amenable to the ideas of justice that we've been seeking for so long. And we've not been getting there as quickly and as effectively as we needed to be. And so with these developments in international law and these ideas on climate reparations coming up, we do have a chance to shape multilateral systems and international systems to work better for us, and move away from these systems of oppression towards, I guess, a transformative shift into systems of change. And so looking at the whole, I guess, not looking at the doom and gloom, but the opportunity that this provides in terms of rethinking what could be possible if we take a chance.
Thank you. We have 3 more minutes. Anything else? Any other points? Oh.
Yes, thank you. I had a question about, there was very recently an outcome in a legal case of a company, RWE in Germany, being, now I don't know exactly the outcome of the case, but it was clear that there was a responsibility for companies as well, for reparations. So I was just wondering how those two are connected. So what is the role of governments versus what is the role of companies in this?
Yeah, I think corporations have their own obligations also, of course, to respect human rights and to make sure that their operations are in line with human rights. But I would say that what, of course, is also the expectation of these advisory opinions is that the legal clarity is going to give on how states are supposed to also regulate corporations, and also in terms of ensuring, well, again, that preventing harm, but also redressing harm. And I think that is also an interesting loop back into this process, because what should become very clear is that based on the polluter pays principle, states have to regulate their corporations. They have to make sure that corporations pay for the harm that they have caused, and that can actually be a very important source of public finance to come back into this process, climate finance for adaptation, for loss and damage, for remedying the harm, which is something that here we've seen voluntary approaches, voluntary pledges. There is this argument that there is no money. Of course, that is very questionable when you see how much money is now going into militarism. So there is the money. It's just a way of channeling it through the right resource, the right channels. And this legal clarity can, of course, contribute to making sure that those channels are being set up outside and inside this space, I would say.
And with this, I would like to thank you all for coming, and our panelists for giving us their insights. And really just want to leave with this reminding that I hope we have established that climate reparation is a demand for justice, and a demand that is anchored and based on human rights. And repeating what Adriana said is how do we move from assistance to justice? And this should be the core of these negotiations. Thanks.